In this unit, we will examine the opportunities and mechanisms for protecting the intellectual property around your medical device. To begin with, we need to clearly understand the prior art in the field. That means searching the published patent literature for keywords related to our design. While patent agents can provide this service for a fee, it is more effective to perform a preliminary search based on online resources in advance of hiring third parties. A patent is a document which describes an invention and its inventors. An inventor is any individual who has contributed to the ideas and intellectual content of the patent. Patent document style differs from one jurisdiction to another, but will usually consist in details of the inventors and a short abstract followed by a description of the prior art. The invention is described with figures and annotations where possible, and the final section describes the patent claims. Patent claims define the uniqueness and originality of a patent. To be patentable, it is important that your design does not infringe or overlap with existing claims in provisional, granted or even expired patents. Many online resources will facilitate this preliminary search. The aim of this search is to identify claims from existing patents which will overlap with your design. Where clear overlaps exist with granted patents, it may be necessary to revisit the design. However, often the overlap is ambiguous, and you may need the advice of a patent agent in this case. Most patents have a lifetime of 20 years during which it remains the property of the inventor. In some cases, your invention may overlap with expired intellectual property. While this allows you the freedom to operate using the principles of the expired patent, you cannot patent a previously filed claim or concept. Once you are satisfied with the uniqueness and originality of your design, you need to choose in which jurisdiction you will protect your intellectual property. Almost all countries protect the first applicant to file a patent application. However, in the event of a dispute, your design records and logs will be critical to protecting your filing. It is also critical to avoid any public disclosure of your ideas until your patent application is complete, as this will invalidate your application. The Patent Cooperation Treaty is a way to simultaneously file your patent claims in over 140 different countries with a single application. While it is not an international patent, it provides a centralised filing procedure in advance of entering the national phase in individual countries. PCT applications begin with a local application, which, in Europe, can be made to either the National or European Patent Office, followed by a full PCT application within 12 months of the local application. PCT applications become public at 18 months after the local filing, and applicants will be provided with a search report within 4 to 6 months of the PCT application, and earlier if the local application was made to the European Patent Office. Usually, this time involves a series of correspondences between the inventors, their patent agents, and the Patent Office in order to delete, amend or review claims which may be identified by the Patent Office as infringing. In the event that the patent is deemed original and unique, the inventors will need to choose which jurisdictions to protect their intellectual property within 30 months of the local application. The vast majority of medical devices are filed as utility patents. Design patents also exist, but are usually reserved for ornamental and non-technical claims. In the US, applicants have the option to file a provisional patent, which is simpler and less costly than a full patent application. US provisional patent applicants then have up to 12 months to file a full patent application while retaining the precedent date of the provisional application. Software cannot be patented in Europe, although algorithms which are implemented in software may be patented. In reality, many software developers choose to keep their software code secret rather than disclosing it through patent filings. Once the Patent Office is satisfied that the patent is unique and original, it may grant a full patent. Patents are self-enforced, which means that the onus is on the inventors to identify infringement of their intellectual property rights. Intellectual property protection is a long and costly process. However, this unit should enable you to make a preliminary search of the prior art by systematically searching keywords related to your device design. If your product is novel, then the search results should enable you to identify the key claims related to your design. Finally, you should be able to describe the general purpose of the invention, the problem which it solves, how it operates, and the advantages of your invention over existing methods or devices. This input, which should be captured in text format, will enable a patent application for your product.